Hello, everyone. Thank you so much for coming today. So we're expecting the rest of the mentees to join us, and I hope that they join us soon. I think I just saw Mr. Justin. So we'll be starting shortly. My name is Juliana Imam, and I'll be anchoring the session for today. I'll just go quickly to read out who we are. Okay, so about the program, JIIPCC Mentorship and Internship Program is a quarterly intellectual property mentorship program for law students, young lawyers, and intellectual property enthusiasts across Africa. Mentees are afforded the opportunity to access valuable intellectual property advice, training, network mentorship, internship discussion forums, industry updates, and resource materials from experienced IP mentors. This program seeks to encourage continuous intellectual property training, development and evolution in Nigeria, Africa, and around the world. Our hashtag is JIIPCC, and you can also watch our videos by searching for JIIPCC on YouTube or Facebook. The objectives of this program is, one, to provide easy access to intellectual property guidance, training, and resource materials for students, young lawyers, and IP enthusiasts in Africa. Two, to facilitate dialogue and network among experienced and less experienced intellectual property practitioners and stakeholders. Three, to transform mentees into intellectual property mentors and leaders for the next generation of mentees. And four, to facilitate further intellectual property mentorship, internship, scholarships, and IP-related job placements for mentees. I'm excited to say that we're in the third quarter for this year, and we have about 18 mentees, and they'll be joining us shortly because they are supposed to also present today. So they are supposed to present for about 5 minutes, and then we go straight to listen to the mentors. So I would like to just go straight to group 1, group 2, or group 3. Please, if you're around, kindly unmute yourself and present. Do we have the presenters for group 1, group 2, and group 4? Do we have any of the presenters here? Okay. So if they are not here with us.
Good evening.
Okay, good evening, Neka.
Good evening, ma. Group 1.
Good evening.
Okay. Thank you, ma. Let me share. Good evening, ma. Good evening, everyone.
Good evening.
I'm coming. Let me share my screen.
Okay. Okay, so you have 5 minutes. What's your topic?
Okay, 5 minutes.
Yes. What's your topic, Neka?
Copyright.
Okay. Let me see if I have it.
Copyright.
Okay. Let me see if I have it. If it's this. Let me see.
Do you have?
Sorry. Not this. I'm coming. Sorry. Okay, is this yours? Neka, is this yours?
Yes.
Okay.
Yes, my can.
Okay, so you can continue.
That's it.
Okay.
Okay. Please help me click on the. Okay, our topic is on copyright, and we have an outline, the meaning of copyright laws in Nigeria, how to register a copyright, infringement of copyright, and then legal remedies. The next one, ma. The first one.
Sorry. What is copyright?
Can you
Sorry.
hear?
Yes, I can hear you. Sorry for the delay.
Okay, ma, there's no problem. Let me continue.
Okay. Can you see the screen?
No. Let me just
Okay,
continue.
Okay, yes, please continue.
Okay.
I can see the screen. I can see your screen, yeah.
Okay, thank you.
Okay. Let me continue then. Copyright is simply the exclusive rights granted to an originator of a creative work to reproduce that work for a limited period. However, not all works qualify as copyrights. The Act seeks to protect the creative works of authors, artist works, songwriters, music publishers, photographies, etc. The Copyright Act is the principal law that governs and protects copyright in Nigeria, while the agency that supervises copyright registration in Nigeria is the Nigerian Copyright Commission. The Copyright Act makes provision for the protection, transfer, infringement, and remedies for infringement of copyrights in Nigeria. Now, who qualifies for copyright protection? Section 1 of the Nigerian Copyright Act provides that the following works can qualify as copyright. 1, literary works, musical works, artistic works, cinematography, sound recordings, etc. However, these are under certain conditions, and these conditions include: 1, there should be sufficient effort expended in making the work to give it its original character. 2, the work has to be fixed in a definite medium of expression that is now known or to be developed later, from which it can be perceived either directly or with the aid of any machine. At the time the work was done, it was intended by the author to be used as model or pattern to be multiplied by an industrial process. The next one is registration of copyright in Nigeria. 1, it is important to state that registering a copyright is not a precondition for the work to be protected. However, copyright may not need to be registered. The rights enjoyed simply activates automatically when the work is created. However, a registered copyright with the Nigerian Copyright Commission prevents others from copying the work, and it protects the author from any form of infringement. The application for copyright is, however, submitted to the office of the Commission, accompanied by the prescribed fees, a completed registration form, and copies of the work to be copyrighted. It is also necessary to state that the registrations are through the Nigerian Copyright e-registration system. When you register, the rights enjoyed by the license holder are limited to the duration of the lifetime of the holder and 70 years after his death. For the films, sound recordings, performances, the holder enjoys copyright for 50 years from the time the work was first published. Copyright infringements in Nigeria. Section 15 of the Copyright Act, Laws of the Federation 2004 provides that the rights of the copyright owner will be deemed to be infringed by any person who, without the license or authorization of the owner of the copyright, does any of the following acts, namely: 1, does or causes any other person to do an act, the doing of which is controlled by copyright. B, imports or causes to be imported into Nigeria any copy of a work which, if it had been made in Nigeria, would be an infringing copy under this section of the Act. C, exhibits in public any article in respect of which copyright is infringed under paragraph A of this subsection. D, distributes by way of trade offers or offers for sale, hire, or otherwise any papers prejudicial to the owner of the copyright, any article in respect of which copyright is infringed under paragraphs A of this section. However, there are other forms of infringements which because of time I will not delve into. Then the remedies to these infringements are: one, the remedies may be civil or criminal. Civil remedies may include conversion rights, damages, injunction, and account for profits. An unpopular order is also available, is also an available remedy. This order is given for the inspection, photographing, and delivery up of infringing materials in the possession or control of an infringer. Criminal remedies include penalties or fine and terms of imprisonment. So this is the presentation by Group 1. Thank you.
Thank you very much, Nika. So let's hear from Group 2 and Group 4.
Good afternoon.
Good afternoon, Omotoye.
My name is Omotoye, and I'll be representing Group 2 in our presentation on collecting societies. Give me a moment to share my screen. But while I'm doing this, I think I should just let me give a background of what collecting societies are. Now, to start with, okay. Now, to start with, if I can appeal to our senses of copyright, up to our knowledge of copyright, I think I'll start with, let's say, Wizkid's latest album. Those that are familiar with it would recognize that the album Made in Lagos Deluxe is like the most popular album in Nigeria at the moment. It is playing across all the airways, and if you go from Boomplay to Spotify to even radio stations, it is playing everywhere. And you have to ask yourself this question: how is Wizkid going to generate resources from? How is he going to get paid from these people playing his album everywhere? How is he going to get the money he has spent on it? Now, if your answer is it goes about from one platform to another, from one radio station to another, then you are probably assuming Wizkid is a superhuman, which he isn't. But the easy solution is that he uses this collecting society, or at least I hope he does, because it is like the easiest way for him to generate to get his royalties. Now, to start with, collecting societies are actually organizations or a group of people that come together for the purpose of licensing or managing the copyrights of other people or their own copyrights themselves. So it is like a group of copyright authors. As we know that copyright is only ascribed to creators. So these collecting societies are actually a group of people that come together to help themselves or their members with receiving their royalties, with licensing their works, with the distribution, with all the costs or all the benefits they can get from copyright. Now, these organizations, I'm trying to rush through everything. Now, these organizations come together, or they are an association of copyright owners. So their objective is that they negotiate and they grant licenses, they collect and they distribute royalties in respect of these copyrighted works. So only people that have copyright get to be members of this collecting society. Only they get to benefit from copyrights. Only they get to receive royalties from these copyright societies. And to discharge their functions, the copyright societies can sue, they can institute civil proceedings on behalf of their members. All right, let's go to the functions of these copyright societies. So their major function, as I said earlier, is that it's licensing and collecting licensing fees on behalf of authors. That is all the benefits that the copyright authors should generate from their works. These copyright collecting societies, they do it on behalf of their members. They license it, they receive the licensing fee, and then they remit it back to the members or the authors as royalties. Now, it is very important to know that this licensing or this function of collecting society is discharged based on instructions. Now, there are two ways where these collections can be managed. It is either voluntary collective management or the mandatory collective management. Now, the voluntary one is where the right holders get to choose, get to decide how the collecting society grants their benefit or how the collecting society enforces their copyright. So the example of Wizkid that I stated earlier, Wizkid gets to decide whether his collecting society should go to certain places, whether they should charge radio stations or not, whether they should collect his benefits, his royalties, his licensing fees, whether they should collect it from this particular place or not. It is up to him to decide. Then the mandatory part is that he automatically, by being the member of the collecting society, is obliged by law. Is obliged. He has this benefit by law that he has to. The copyright collecting society has to collect his licensing fees on his behalf because he is a member. So every copyright holder that is a member of a collecting society has this mandatory benefit they enjoy from being members of the collecting society. The next thing is the regulation of collecting societies. Now, how are these things regulated? We all know that copyright is regulated, as the previous speaker said, copyright is regulated by the Nigerian Copyright Commission and the Nigerian Copyright Act. Now, the Nigerian Copyright Act in section 39 provides for copyright collecting society. And it regulates their activities, it regulates how they interact with their members, it regulates the limitations and the extent of the display of their power. It regulates how far they can benefit their members. Next one is the limitation of the collecting society. Now, their limitations, as I said earlier, is subject to their members. It's subject to the instructions their members give to them. But apart from the fact that it is subject to the Nigerian Copyright Act and the Nigerian Copyright Commission, it is also subject to the members. It is subject to the instructions, the explicit instructions of the copyright holder. While finally, it is subject to jurisdiction. As we know that all intellectual properties are limited to the locations, like geographical indications is limited to particular places where they are being displayed. So copyright collection is also limited to the areas where the copyright is being displayed. So in Nigeria, I can enforce my copyright in Nigeria, but it doesn't mean I can enforce it in the United States. This is where the copyright collecting society comes to play. The limitations of the copyright collecting society is that it cannot collect beyond its jurisdiction, but it can always work with the copyright collecting society outside its jurisdiction to get the benefits for its members. So I hope that this presentation has been enlightening to you. Thank you.
Thank you very much, Motoye. Thank you for just going beyond and trying to explain it for us to understand better. So the last group can go ahead to present. Who is presenting for group, I think 4 or group 2, I'm not sure. Is it Grace?
Yes, I'm the one presenting for group 4.
Okay. Will you be able to share? Okay, good. Okay, so you
Good
can
evening.
continue.
Okay, good evening, everybody. So group 4 is supposed to talk on royalties. Okay, so basically the concept of royalties are fees that individuals have to pay to the owners of the copyright work for them to use their work. So if you've written a book or you've composed a song and your song is out there and people want to probably use your book for educational purposes or for commercial purpose and all of that, they have to pay a certain amount to you before they can use your work. So that is basically what royalties are about. So it's payments that individuals pay to the owner of the copyright work in order to use that copyright work so that you won't be liable for infringement. So once you're able to get a license from the owner of the copyright, you can no longer be liable for infringement or improper use of the copyright work. So basically that's what royalties are. They are payment or fees paid to the owner of the copyright work in order to use his work for commercial or private use. Okay, so yes, thank you. So now we'll go to types of royalties. So the different types of royalties that we've been able to bring out, performance royalties, image royalties, book royalties, patent royalties, and okay, so I'll just explain maybe like 2 or 3 of them. Performance royalties, basically this has to do with music. So these are royalties paid to artists and producers of musical work to be able to use their work. Like the example the last presenter used of Wizkid, and also to be able to play Wizkid's song in your TV station or in a radio station, you have to pay a certain amount to Wizkid, or you have to pay a certain amount to Wizkid through the collecting societies, like we've just heard. So basically that's what performance royalties is about. Then image royalties, this has to do with pictures. This has to do with pictures. For instance, if you're a photographer and you've been able to create a brand or create a name for yourself and you put your pictures out there for people to be able to use your pictures on maybe their TV channels, their websites, their if for people to be able to use your pictures, they have to pay for it. So image royalties are royalties paid to photographers and creators of images. Then book royalties, as the name says, for authors of books. So if you write a book and probably schools or institutions want to use your book, they have to pay to you, and that's basically what book royalties are. Then I want to talk about franchise royalties. This comes into play where probably a business has already been established somewhere and you want to use the name of that business to trade or to create a business. For instance, Mr. Biggs or KFC. So if you want to open a branch of KFC somewhere where you live, or you have to pay franchise to the original owner of KFC. So that's basically what franchise royalty is about. Next slide, please. So those are the types of royalties that we have. Okay, so now before you go into payment of royalties and all, the owner of the work and the person seeking to use the work have to enter into what we call licensing agreement. So a licensing agreement basically just talks about the whole contract and all. It describes the copyrighted work that you want to seek a license to use. It describes the work and what the work entails. The agreement also will also capture the scope of your use, like how you can use it, your limits, your limitations, and all of that, the duration, the time you can use it. A licensing agreement also contains things like the payment, the method of payment, how you should pay. Is it monthly? Is it weekly? Is it yearly, annually, and all of that? So basically, a licensing agreement, it just covers everything that has to do with the payment of fees, the scope of the work, the copyrighted work, and everything regarding your use of the work, the permissions, the limitations, the boundaries that the owner has given you, and all of that. So basically, you have to enter into a licensing agreement with the author or the owner of the work before you can use it. Next slide. Okay, so how do you now pay such royalties? First of all, you can so this is basically talking about how to do evaluation of the fees to be paid to you as the owner of a copyrighted work. So you can do evaluation based on the cost of your work, based on the market value of your work, or based on income. Next slide. Okay, so what are the factors that can affect the amount of royalties that someone can pay to you? First of all, the strength of your intellectual property protection. If your intellectual property is weak, or if you don't, if for instance, if you're supposed to use get copyright for a work, and then you're maybe trying to seek patent, or you have patents protecting your work and all of that, the strength of your protection won't be strong. So you have to know which of the intellectual property platform you can use to protect your work. So that's basically what strength of your work, your protection means. So so that can also affect the amount that someone can pay to you. Then the stage of your product, the stage your product is, like if you just got copyright for your work like maybe 1 year ago, 6 months ago, you don't expect that somebody will pay the exact amount like someone that has gotten copyright for like maybe 10 years ago, or someone whose product is well known in the market. So that also can affect how much can be paid to you. The strength of your how unique your invention is to can also affect how much can be paid to you. The level of competition in the market, and several other factors. So you have to know all those things. So as the owner of the copyright work, you have to take all those things into consideration in charging a fee for your work. Okay, so next slide. So okay, so this is now next slide is talking about the structure of the fees to be paid. Like, how do you want your fees to be paid? Is it via percentage, like probably 50% of the amount that the licensee generates, 10% of the amount that the licensee generates from using your work? Or is it going to be a fixed rate, like pay me 2 million every month, or pay me 5 million every month? So that's you can be paid via percentage, you can be paid through a fixed rate. And then the one I really want to talk about is this variable percentage. Now this option is open for someone whose work is new, and probably the work has not been tested, and probably people have not really accepted the work yet. So you don't just go and charge so much, but you just charge a little, and then in the beginning you charge a little, and then if you see that your product has really been accepted and it's generating more income, then you get to increase the fees as time goes on. So basically, now there's also something called minimum royalty rate. So this is like, I don't know if it's the collecting societies that set this particular rate, that there should be a minimum rate that people shouldn't go be. There should be a minimum fees that maybe an author won't go below. So basically that one too is there, all of that. Next slide. So royalties can be charged, I've said it, they can be charged monthly, quarterly, annually, depending on what the author of your work, depending on what the author of your work wants and all of that. So, okay, so royalties basically are income. So they are liable to be taxed. So I really don't know how royalties are taxed. I think that I should have added that to one of the questions I wanted to ask. So like, how are royalties taxed? How do like FIRS, how do they know how to tax? How do they know how to even calculate royalties and then to tax them? So I'm throwing this out to our mentor in the evening. Please help me explain how their royalties are taxed. So so the next slide is talking about the advantages of royalties. So you've put in a lot of hard work to create your work, to put your work out there. So what are the advantages of people paying you to, use your work? First of all, for me, one of the advantages of this is people get to see your work, because if your work is not thrown out to the public, people won't get to see. First of all, they get to see your creative work, your invention. Your name goes out there even before the money comes, and then so it allows others to use your property for a fee. Sorry. And then royalties also protect the buyer from claims of improper use or infringement. I think I already mentioned that. And so basically, that's basically what royalties are. Thank you for listening.
Thank you very much, Grace. Thank you for the presentation on royalties. Great work. So we'll just go straight to our mentors that are already here. Most of the things that we have said are things that we have been able to research, but would like to hear from the mentors who are in the who actually practice and know more about this. So I'll be reading out the profile of our first mentor that would be talking. She would be speaking on copyright enforcement and collecting societies. And then our second mentor will be talking about collecting societies and royalties from a practical point of view. So our mentor for today is Dr. Chijioke I. Okorie. She's a lecturer and researcher at the Center for Intellectual Property Law, Faculty of Law, University of Pretoria, South Africa. She obtained her LLB from Nnamdi Azikiwe University, Accra in 2005, her LLM in Internet Law and Policy from University of Strathclyde, Glasgow in 2014, and her PhD in Commercial Law, focused on intellectual property and competition law from the University of Cape Town, South Africa in 2018. Dr. Okorie was called to the Nigerian bar in 2006 and was in 2019 and 2020 a postdoctoral research fellow in IP, innovation and development under the University of Cape Town's DSI NRF SACHI chair on IP, innovation and development. She was visiting postdoctoral research fellow in the Center for Law, Technology and Society Law Faculty, University of Ottawa, Canada in 2019. She's a Queen Elizabeth Scholar, Canada, and a research collaborator with the Open African Innovation Research Network. Dr. Okorie is a member of a number of professional and academic associations, including the Nigerian Bar Association, International Association for Advancement of Teaching and Research in Intellectual Property, ATRIP, the Society of International Economic Law, the Nigerian Association, and the South African Association of IP Law and Information Technology Law Teachers and Researchers. Dr. Okorie is the author of the monograph, Multi-Sided Music Platform and the Law, Copyright, Law and Policy in Africa, Royalties 2020. You're welcome, Dr. Chijioke. We're excited to listen to you.
Hi, everyone. Thank you, Juliana.
Thank you.
I'd like to commend all the presenters for a well thought out presentation on the various topics that we'll be discussing today. I'm also excited to see that Justin will be talking about collecting societies. That I think that makes my work easier as well. And I like that the presentation focused on even went a little beyond the basics to talk about copyright, the bundle of exclusive rights that are protected, issues around what will constitute infringement, royalties, collecting society, so that we don't need to dwell on that. And so I'm going to just limit what I'm going to say to the area of certain issues that come up in relation to copyright and prosecuting copyright infringements before the courts, and issues around copyright limitations and exceptions, and relying on those as defenses in an action for copyright infringement. As I'm sure that we would all have noticed when we were preparing our various presentations for today, copyright on its own is quite a vast subject area. And so some people have even said that the whole grouping of copyright and patents and designs and trademarks and other related intellectual property under the umbrella of intellectual property law is quite unworthy, because there's each of these, substantive IP rights have, their different topics and issues and subject matter of discourse, such that you won't even be able to exhaust the entirety of copyright alone in just a day or even in a semester. So when I talk to the students, I teach undergrad students and postgraduate students as well in intellectual property, and even in a semester of three months, you find it difficult to cover the entirety of copyright. So there's always a move to ask people to go beyond, maybe the undergraduate degree to pursue postgraduate studies in intellectual property, and to even then narrow it down to maybe copyright or trademarks or designs or patents, whichever one catches your fancy. So without much further ado, I wanted us to talk about, to narrow things down a bit and talk about copyright litigation, and specifically to talk about the case of Raconteur Productions Limited against Dione Visions, because I feel that in many ways that case represents some of what copyright law practitioners and even anyone interested in copyright law tries to navigate in terms of enforcing their copyright protection. So that case is quite popular because of the key players or the parties involved in the case, and it relates to copyright infringement of a screenplay produced into a feature film entitled Okafor's Law. So I'm sure if we're following the news, we would have heard about it. And basically, the case was essentially that the plaintiff was accused the defendant of infringing its copyright in a screenplay that he had written for a feature film. And the case garnered a lot of interest at its inception, mainly because the plaintiff had first obtained an interim injunction from the court, restraining the defendants from holding their planned premiere for the feature film. And the crux of the plaintiff's application for injunction was that the screenplay for the feature film was substantially similar to and also infringing of its screenplay with a similar title. And the plaintiff in that case had registered its title to the screenplay in question with the Writers Guild of Canada. And so the court granted that interim injunction. And because of the fact that the court granted that injunction, the defendants could not hold the premiere of the movie, and they could not even distribute the movie without approaching the courts to set aside that interim injunction. And the court subsequently lifted the interim injunction and held that it was granted based on insufficient evidence and because the copyright claim was yet to be determined. And so the court then went on to deal with the substantive issues, took evidence in the case, and ended up dismissing the plaintiff's case. And the main reason why the court dismissed the plaintiff's claim was because the screenplay in question that was alleged to have been infringed was not presented in evidence before the court. And basically, the court was called upon the court felt that the starting point in establishing, that in establishing the plaintiff's entitlement to the relief of damages against the defendants for copyright infringement was that the plaintiff needed to show that they owned a valid copyright and that the defendants had, proximity and access to the work, and that they copied constituent elements of the work that are original. I think it was Nneka that mentioned that one of the eligibility criteria for copyright protection is that the work has to be original. And so in proving infringement, you also would then need to show that the defendant's infringement or copying of the work was that you need to show that the defendant copied the constituent element, that is the element of the work that makes that work original. And that there was, of course, substantial similarity between the constituent, that's the original elements of the plaintiff's work, and that one put out by the defendant. And the court felt that because the plaintiff did not produce physical evidence of its screenplay, that the screenplay that it alleged had been infringed, that because it didn't produce that in evidence, that there was no basis to consider the infringement claim. And so the court dismissed the plaintiff's suit. And I feel that this case represents various missed opportunities as far as copyright litigation in Nigeria is concerned. Firstly, because, of course, generally because we did not have the opportunity to procure judicial precedents for the copyright community in Nigeria on the question of screenplay litigation and the factors that the Nigerian courts would find applicable in conducting a substantial similarity test. So the case was not decided on its merits. And one of the missed opportunities is that the plaintiff hinged its claims on the allegation that it gave the third defendant access to its screenplay during discussions for co-production projects. And again, it highlights one of the things that the presentations have shown us today, that usually copyright owners, authors, artists, and the like are usually reluctant to share their work to a third party because they don't want to risk the work being infringed. And in this case, the plaintiff was saying, in the course of discussing, opportunities for co-production of the feature film, that it gave access to the third defendant, who was a distributor and a producer. It gave access to the third defendant. It gave them access to the said screenplay. And to resolve the issue of access, the court needed to see what was given to the third defendant so that it can compare it with the plaintiff's screenplay in issue. And in this case, of course, again, there was no screenplay for the court to compare what was said to be infringing with. And then the second missed opportunity was that the plaintiff also produced reports from two professional writers as experts that would analyze, the plaintiff's screenplay and the defendant's screenplay to show similarities. The experts did that and prepared a report, but the experts were not called as witnesses in the case. And so the courts decided that the expert's report, which was presented through another witness, amounted to hearsay evidence, and rightly so. And so we lost the opportunity with that case to see what experts in the screenwriting sector would what they would consider as copying or similar, and which expert opinion the court would have found, acceptable. And the third missed opportunity for certain judicial precedents in screenplay litigation was the failed claim of the plaintiff for an order of mandatory injunction requiring the defendants to publish notice in dailies, on a radio station and on a national television channel disclaiming authorship of the screenplay in their feature film. So obviously the plaintiff wanted a situation where the attribution of authorship in the screenplay would be ascribed to the plaintiff as the one that drafted the screenplay. And so because that was not done, they wanted that publication to happen after. And we lost the opportunity to see what the court would consider an appropriate remedy if the right author or the right author, if the right author was not named as the author of a literary work or of any copyright protected work, as a matter of fact. And so we don't know what would happen. So usually we know that in feature films, for example, you find that the cue sheets, so the screen credits that appear at the end of the movie will tell you those that were involved in the production of the movie. So the person that wrote the screenplay, the name will roll across the screen, the cast and crew, the production crew, everybody that played a part in the production of the film. And that's what people look at to then say, oh, I would like to hire or commission this screenwriter to write a screenplay for me, or to do such and such thing for me in relation to my protected work. So it's when you miss that opportunity as a screenwriter, you're not able to, quote unquote, advertise your work. And so to round off on this aspect, we missed the opportunity to be able to get judicial precedent on these matters. But more importantly, it shows us and gives us and teaches us the lesson that when it relates to copyright infringement, when it relates to copyright protection, that as a copyright owner or as an author, or a legal practitioner representing an author or copyright owner, we have to be mindful of these things, so that when we are presented with issues like this, we would be mindful as to how to go about it in order to ensure that we get the best results for whoever or whichever party that we are representing. And then quickly on to the matter of copyright limitations and exceptions. For want of time, I'm only going to say that copyright is not just about the exclusive rights. It's also about the limitations and exceptions that the copyright statutes makes with respect to the exclusive rights. So the rights that copyright law confers on authors and copyright owners is not absolute in its entirety. The rights are also subject to and constrained by limitations and exceptions. So in the Nigerian Copyright Act, you have limitations and exceptions such as fair dealing with the work. And in that regard, if the defendant's activities in relation to a protected work relates to research or private study or personal use or criticism or review of that work or reporting current events, teaching and education, things like that, specifically mentioned in the Copyright in the Copyright Act. If the defendant's activities amount to those things, then the law deems it that copyright has not been infringed by those activities. So even when those activities would ordinarily, in the absence of those exceptions, even though the activities would amount to the same activities that have been exclusively reserved for the copyright owner, the law will still take it that copyright has not been infringed. So in an action for copyright infringement, a defendant will be entitled to, if the defendant's activity falls within those circumstances, the defendant will be entitled to raise those limitations and exceptions as a defense to a claim for copyright infringement. And if the court finds for the defendant that those activities constitute fair dealing, for instance, then there would be no copyright infringement. And those limitations and exceptions also provide an avenue for people to be able to explore and do something with copyright protected matters beyond what an artist or an author or a copyright owner would do with those works. So you find things like, in the case of, for instance, in the US, for example, it's their Copyright Act provides for fair use instead of fair dealing. And fair use, of course, is wider and has its own factors that the court is supposed to consider. And because of those limitations and exceptions, you find companies that, like Google, for instance, or like with YouTube and the other products that Google is known for, those products rely on those kinds of limitations and exceptions to then design their business models around those areas. So I'm going to stop here, and if there are any questions, I'm happy to take them, and comments as well. Thank you.
Thank you very much, Doctor. We sincerely appreciate your perspective in discussing copyright and enforcement. Before we just take the questions, we would like to hear from Mr. Justin Ige so that we can take all the questions together. But just before I read out his profile, I would like to acknowledge that Mrs. Uche Wankocha is here. She is also a mentor, and she has been here through the second quarter and this third quarter. Thank you so much, ma'am, for joining us today. So I'll just go ahead and read the profile.
Thank you, Juliana.
Thank you, ma. So I'll just go ahead to read out the profile for Mr. Justin Ige. As an attorney, his work experience as it relates to music copyright, collective management, and enforcement is perhaps unrivaled. His work over several years has expanded the frontiers of compliance with the copyright law to include historic payment of music royalties by major broadcasting organizations, hotel owners, telecommunication companies, locals, and multinationals. Despite strong resistance, he has successfully negotiated some of the most important agreements and has successfully prosecuted some of the most important cases in the development of collective management in Nigeria. He was in 2015 entered into the Copyright Society of Nigeria Roll of Honor in recognition of his outstanding contributions to the promotion of copyright culture and the defense of the rights of creative people in Nigeria. Justin has, as a guest on several radio and television stations and through several publications, discussed a multitude of media, entertainment, and advertising law issues in Nigeria. He once maintained a weekly media and entertainment newspaper column in a popular national daily. He has served as legal consultant, solicitor, and attorney on a myriad of issues relating to copyright and technology, visual arts, film and audiovisual works, financing, production, distribution and marketing, media, advertising, music production, music publishing, music licensing and royalties, events, concerts and tours, hotels and hospitality, talent and artist engagement and management, etc. As a creative, Justin is familiar with the art of music composition, arranging, recording, production, programming, mixing, and mastering. His practice area are media and entertainment law, dispute resolution and conflict management, legal consultation and advisory, copyright management and regulatory compliance, copyright and commercial law, real estate, intellectual property law, debt recovery and receivership, membership of professional bodies. He's a member of Nigerian Bar Association, is a member of Chartered Institute of Arbitrators UK, and his qualifications are from University of Ibadan, LLB, Nigerian Law School, BL, Polytechnic Ibadan, ND Music Technology. Thank you so much, Mr. Justin, for joining us today. And I'm excited to hear about the practical aspect of collecting society and royalties. Thank you, sir. Okay, so I think we can hear you. Maybe you can.
Can you hear me?
Yes, sir.
Can you see me?
Yes, sir.
Okay, great. My name is Justin Ege. Essentially a media and entertainment legal practitioner. So I don't know where I'm going to start now. The presentations were good, and the first speaker was also excellent. So I don't know what's left for me, what was left for me to say, you know. But let me just try and quickly do a brief summary. You see, when we're talking about collecting societies, you have to understand what a collecting society really is, right? Collective societies are also known as collective management organizations, meaning that they manage copyrights. They're involved with the administration and management of copyrights, and they do it in a collective capacity. So they manage it as a collective, not necessarily as individual rights, as I think one of the presentations seems to suggest, you know. So they manage it, you know, as a collective. And then also, when we're talking about what collecting societies do, they also operate essentially I say, because there are exceptions, essentially in a representative capacity, right? They operate essentially in a representative capacity, you know. And then what else? Yes, I think this was particularly missed, or it was hinted but not emphasized enough in the presentations. You know, there are different types of collecting societies. You know, we have collecting societies for categories of works, you know, whether it's musical works, sound recordings, or the visual, you know, literary works. You have collecting societies, you know, for that. And then within musical works, you know, we have collecting societies that are only for particular rights or a group of rights, you know. So you have those that are the most popular are called PROs, Performing Rights Organization, you know. I saw something in one of the presentations that talked a little about performing rights, you know. But the most important thing to note about performing rights, which I think that presentation either missed or did not, you know, emphasize well, which is very important, is to know that the performing or the performance we are talking about is public. We're talking about public performance, not private performance. You know, of course, we know what the definition of public in law means. I don't have to start, you know, going there, you know. So that is the jurisdiction, if you like, for collecting societies, you know, for performance. And then of course you have those for the mechanical rights as well, you know, which essentially is a reproduction right. There are other reproduction rights, of course, outside mechanical right. There are synchronization rights, which collecting society don't usually deal with. I say usually because there are also exceptions, you know. So yes, some might say, let's go a little bit into the practical now. You know, some might say, you know, all of this is just theory. You know, it doesn't work in Nigeria and all of that. You know, I want to say that that is not true. If all these things don't work in Nigeria, I won't make a living. You know, and I am making a living. You know, so it's working. It's not working as well as we would like it, you know, but it's working. We've had some setbacks in the last 3 years. You know, I've been involved with this for, shall I say, over a decade. You know, but the last 3 years have been particularly painful because some developments have set us back, you know, for many years. I don't know when we are going to recover from you know, the happenings of the last few years, particularly the shall I say, the involvement of the Attorney General in this space. You know, it's been rather destructive. Destructive, I didn't say destructive. Destructive, that's negative disruption. You know, so it's not working as well as prior to 2017, you know, and but there's hope for the future. You know, there's hope for the future. The environment is constantly changing and all of that. So I don't know what else should I need to touch on the practical aspect, you know. So yes, of course, like the presentation said, there's the question of mandate. You know, there's a mandate. There are some things that the presentation touched about when it comes to mandate that are not exactly reflective of the Nigerian experience, which I would assume, you know, is where we are focusing on, you know. So mandates in Nigeria for collecting societies is dual, essentially. You know, one is by direct membership, you know, so collecting societies have the mandate to represent particular right owners because those right owners are, you know, their members. You understand what I mean? They're members. So there's that direct membership, direct representation on account of that. And then there's the other one, which is derived from approval from the Nigerian Corporate Commission. You know, that power is derived, yes, from statute, you know, and the regulation, you know, enacted, you know, from powers derived from statute. That's particularly the the Corporate Act. You know, and what's that mandate? What's the extent of that mandate? It's more like accidental, more like I say, it can be argued to expand a little bit beyond that, you know, but essentially, if you really look at it strictly, it's more about accidental licensing when works are included in blanket licensing, you know. So blanket licenses are where collecting societies license their entire catalog instead of individual works, and that's the most popular type of licensing that collecting societies grant, because that's how they are really essentially supposed to operate as and you know, managing collectively, you know, the rights, you know. So I'm saying a lot of things. I hope I'm not speaking, you know, over your heads, you know, but from that practical aspect, that is it in a nutshell. So questions?
Thank you very much, Mr. Justin. So, so
I can see a question. Why is there no?
I will read out the questions.
Okay, read it. Okay, great.
The questions are for, I think, both of the speakers for today. And then if you have a question that was not captured here, please just unmute yourself and ask your questions. So we have a question from Divine's group, and he was asking that why are there no collecting societies for book authors and other recognized copyright creators? Then number two, he's asking how the collecting societies have been able to help the case of copyright infringement in Nigeria. And then Grace's group is asking that, can a person be said to have infringed on a copyright when he reproduces and distributes a copyrighted work to the public without the authorization of the owner of such work, and at the same time acknowledges the author of such work? Number two, she's asking, from what I understand from the topic, a licensee has to pay the licensor royalties for the right to use copyrighted work. So her question is, for radio stations who play songs of various musicians at least 13 hours of each day and every year, do they pay royalties to all these record labels? Is the cost not too high, so much that it affects the revenue of the radio station so heavily? Humamo Group is asking, one.
You know, the questions are so many, there's no way we're going to remember all of them. Perhaps we take it one after the other.
They're in the chat box. I don't want to read them, and then you can check the chat box and then answer those that are related. Okay, thank you. So Humamon's Group is saying, what is the difference between copyright infringement and plagiarism? And two, may I cut and paste a logo or picture from someone else's website? Thank you so much. So these questions are for Mr. Justin and for Dr. Chijoki. Thank you.
Okay, so I don't know which question is directed to who, you know, but maybe let me attempt to run through those that I can answer, right? So question one, why are there no collecting societies for book authors and other recognized copyrighted creations? We should say copyright works, you know, in the language of the law, works. You know, so collecting societies for books and authors, they exist. You know, they're not as popular, but for books and authors, we have a collecting society for books and authors in Nigeria. It's called RIPRONID. We also have collecting society for audiovisual works. It's called Audiovisual Rights Society. That's AVRS. You know, so for those two, yes, we have collecting societies. You know, how the collecting societies have been able to help the case of, yes, collecting societies have done a lot. I mean, I've filed many lawsuits, you know, representing collecting societies in this country, and we've done a lot. We've done a whole lot. Prior to 2010, you know, when Kusan was approved as a collecting society, a lot of work, perhaps not as much, you know, has been done, you know, but yes, we've done quite a lot. Not enough, not nearly enough, if you ask me. You know, can a person be said to have infringed on a copyright when he reproduces and distributes without the blah, blah, blah. You see, acknowledgement, it does not remove liability for copyright infringement. You know, acknowledgement only relates to moral rights, which is not exactly copyright. You know, it's an associated right of copyright, but it isn't exactly, you know, copyright. You know, so from what we understand from the topic, the licensee has to pay the license royalties for the use of work. The license, well, the licensee has to get a license. You know, the consideration for that license, you know, because every contract must have, you know, consideration, you know, except if it's a deed. So you can make it a deed. So you can get a license by deed. So that way you don't have to pay anything. You know, otherwise, even normal regular contract, you can get a license without paying royalties. You know, royalties are things that you have to pay constantly, you know, going into the future. So you can pay a one-time fee, you know, for a license. You know, that won't be called a royalty. It does be called a license fee. So you can also do that, right? Radio stations play songs of various artists at least 13 hours of the day and every year. Do they pay royalties? They are supposed to. You know, since 2017 or so, I don't know of any radio station that is paying at the moment. It's part of the setbacks that, you know, the Attorney General's incursion into this space has cost us. You know, but prior to then, I know that a few were, or shall I say a good number, were paying, you know, and what they were paying was so minimal. So it wasn't high at all. I negotiated, or I was part of those that negotiated the agreement at 2013 or 14. So it's not high, it was not high at all. In fact, it was too low that it's affecting the revenue of the right owners and those that invest into, you know, making music and all of that. So on the contrary, while they were paying, it was far too low. Right now, I'm involved in an effort to have a new regime where, you know, the rates and the tariff are more value reflective, you know, and more commercially viable. You know, I'm working on that at the very moment. So that's to answer that. What's the difference between copyright infringement and plagiarism? They are similar, but they're not exactly the same. When you plagiarize somebody's work, you're obviously infringing the copyright, but I think you can infringe on somebody's copyright without plagiarizing the work. What does plagiarism mean? It means that you are lifting a substantial part, without giving credit. Without giving credit. If you give credit, you won't be plagiarizing. But with copyright infringement, even if it is one line, if it is substantial in value, not necessarily in volume, and even if you give credit, you could still be liable for infringement. So that's the difference. Perhaps, the doctor will emphasize, may I cut and paste a logo or picture from somebody else's website? Well, you can do that if you have the approval, but you have to be careful or else you can be liable for copyright infringement as well as trademarks infringement if that logo is registered. You can be liable for other unlawful actions other than copyright infringement or trademark infringement. You can be liable for passing off, you can be liable for fraudulent misrepresentation, you can be liable for similar things. So I think I've run through all the questions very quickly, but that's not very detailed. Maybe the doctor will help us go into more detail. I'm not an academic, I'm just a practitioner, I go straight. All right.
Thank you, sir. So let's hear from the doctor with us, Dr. Chijoke.
Okay. Hi again. I think Justin has answered all the questions and he answered this well. And I think that should suffice. Perhaps I would only add to what he has said about the difference between plagiarism and copyright infringement. So maybe I would say that all plagiarism is infringement, but not all infringement is plagiarism. But at the end of the day, plagiarism is copyright infringement, but plagiarism usually comes up most in the academic setting where you are going to, as a matter of necessity, rely on other people's work. So for instance, if you were to be an artist, a music artist, for instance, you would not be, you would most likely be, creating your own musical work, not that you would not get inspiration, quote unquote, from other piece of music, other works, other musical works or sound recordings, as the case may be. You would, but in most cases, there's no avenue basically in that kind of environment for you to say, oh, I borrowed from this person's music or I borrowed from that person's music. But in the academic setting, in most cases, you would need, to show that you relied on other existing work. And when you're doing that, you have to be able to do it in such a way that you attribute, you make the necessary attribution. So if you got a particular idea from maybe a journal publication or from a decided case, you're supposed to say that this is where I got my idea from. And then if different universities and different institutions have their own plagiarism policies, and for wherever one is getting one's degree or certification, you would then need to abide by those rules. There's a case that was decided in Kenya last year on where a university student sued a fellow student for plagiarism and copyright infringement because the person copied the defendant used the plaintiff's dissertation to write a research proposal for a PhD degree. I'll look for the case, and if I can find it, I'll put it in the chat box. So you can then follow through and read the case and see, how the court arrived at the definition of plagiarism and even awarded damages in addition to the fact that the school had already withdrawn the admission given to the student who was accused of plagiarism and expelled the student from the school. So there you have it.
Okay, thank you very much, Doctor. So I guess that we've taken all the questions, but before we go, we have to hear from some other mentors that are around. They might want to drop some comments on the topic. So please let's call on Mrs. Uche, one coacher from Alukanoyebode, if she has anything to add, ma. You're welcome, ma.
Thank you so much. Today has been particularly bad for me with the internet, so I kept going up and down, so I do apologize. What's left for me to say is to thank all the speakers. They did fantastic work. As usual, I always come out more knowledgeable than when I joined, so it's been an interesting session today. I have, however, I have just 2 points, very minor. In case of license, I remember somebody had asked a question on royalty. We don't have legal framework for franchising, and the presenter did mention if you needed to, the franchisor, like the owner of KFC, needed to franchise to a franchisee in Nigeria and all that, and they pay royalty. So I'd like to quickly say that licensing fee is different. It's one bulk. You agree and negotiate and pay licensing fee, and it's part of the consideration, like one of the speakers mentioned, which is key to any contract. But for royalties, and the person who asked the question had said, how can the owner of business be expected to stay in business if you keep paying royalty to all of these right owners? So it's something that is negotiated, and it's a very minute percentage to the actual costs, and then excluding costs, yeah. But that if you wanted to use somebody's intellectual property, it's something that has been developed, something of value. For sure, you needed to pay something to be able to use that. So you negotiate. I've never seen a franchisee that has lost from a franchise agreement. You always gain because it's an established business that you are allowed to use their name, like KFC. If a local business in Nigeria now uses KFC, I mean, it's something that would bring much value to the company. Then for the collecting societies, I'd like to mention that it's really important. It's very key. I liken it to insurance premium. If you keep paying a premium on your car, someday are going to call for it. And then if your car is stolen or you had an accident. So I would really advise that, that IP right owners in any form, copyright or other forms of copyright, must ensure that they sign with a collecting society. Is very, very key. Because the day that you need that, you can't fight a battle alone. So you can always fight in a group, and there's success in numbers. We've had a case where, we have an anti-counterfeiting collaboration that we have in my office at people. So there was a case where one company had infringed on another company. And it was the collective society that we sat around the table, they negotiated and they paid. So it makes it clear and clean so that you're able to use, because you don't want to be seen as a business owner, high profile business, to be infringing on somebody's rights. So, but the collecting society will always negotiate the best fee to pay in order to use it. So I advise that it's something that right owners must consider because it benefits them immensely. That's my 2 cents. Thank you so much.
Thank you so much. As always, you're looking beautiful. And then the knowledge that you brought to the table too was just phenomenal and amazing. Thank you so much, Ma, for coming and always dropping series of advice and contribution for us. We also have Mr. Yokunle Adetula, also from Alukanoyebode. So Sir, please, you are welcome to also give your comments on the topic.
All right, thank you very much. Well, I'm not able to put on my camera for now. Just to say thank you to everybody who's made presentation and the responses to the questions were on point. I can see that doctor has provided the case. I mean, and that is all about the value that comes to these things. So I've learned from this, and I really don't think I will be adding anything. So just to say thank you to everybody.
Okay, sir. Okay, sir. Thank you so much, Mr. Ayokunle. Finally, Mr. Max is here, and also like him to say something before we round up finally. You're welcome, Mr. Max. He is the founder of Everlaw Associates, and he has been a mentor.
Okay. Yeah. Thank you, Juliana. Can you hear me? Hello, Juliana, can you hear me?
Yes, sir. Yes, sir. We can hear you.
Okay. Thank you very much. And I thank the speakers today. Unfortunately, and sadly, I missed their presentation. I particularly was looking forward to Dr. Chijoke's presentation, and then, of course, the presentation on collective societies is an area where lately I've been developing an interest. So I think a very interesting area, and I think something that if we harness properly, able to be of great benefit to the creative industry in Nigeria. So I thank both of them, and I, of course, the other mentors who have spoken before me. I heard a greater chunk of their own input. Particularly, I listened to the response on the question about the difference between copyrights and plagiarism, which I think is a very interesting place, particularly in this internet society we live in now, where you think it's just okay to copy and paste, or to copy and then simply put something small at the bottom, shared or copy. I think there's people who put it on WhatsApp. They say forwarded as received or something like that, and people think that is enough in terms of attribution when it comes to plagiarism. I think it's important people understand, even though we write as practitioners, but it's very important that we understand that from the viewpoint of plagiarism, what you need is not just careless attribution, there must be full and complete attribution, which means you cite the name of the author, you cite the publication or reference it properly so that the person is able to identify where where the material you have lifted is coming from, and then you give enough information to the journalist, book, the year of publication, the name of the publisher, just enough information for anybody to be able to refer back to that source and get more information. So I see that a lot of times you just have a very careless, you just put a few things and assume that is enough when it comes to attribution. As mentioned by Mr. Oni, plagiarism is quite a funny concept. There's no clear definition. There's no law, for instance, on plagiarism that tells us what it is and what is not. But I think one of the best guides to know what is plagiarism and what is not is the Oxford referencing guide, which puts it at lifting anywhere between 7 to 10 words, continuous words from a material. At that point, and if you do that without reference, then you're guilty of plagiarism. So that just helps to give some context to what plagiarism is and what is not, and at least when you have to necessarily reference, of course, like I said, the full citation of where you got the work from. Then there's also a last question about if I copy and paste a logo up from somebody's work, would that be copyright infringement? And I like the answer given myself. I only wanted to add that one area where people don't seem to appreciate is that when it comes to a logo, even though that logo has been trademarked, the copyright in that logo sometimes may not belong to the trademark owner. You commission a graphic artist to design a logo for your, for your company or for your brand, technically the copyright in that logo belongs to the designer, not to you, even though he did it for you, except of course, you can show proper evidence that this was work for hire, you paid him for that, and he assigned his copyright in that logo to you. So this just boils back to what we have spoken about here some while back, that people have to be careful when it comes to engaging photographers, engaging graphic artists and all of that, or website designers. If you don't have proper documentation, then the copyright will still belong to them and not to you, even though, the work is yours and you are the one using it. So these are just some of the interventions I thought I should make. Thank you very much, Juliana. Back to you.
Thank you very much, Mr. Marks. So I would like to say a very big thank you to all our mentors today. Thank you, Dr. Chijoke. Thank you, Mr. Justin Ige. Thank you, Mrs. Uche Wonkocha. Thank you, Mr. Ayokunle. Thank you, Mr. Marks. Thank you to all the mentees and the presentations. Thank you for studying. I would like to say that we will be ending in 2 weeks' time for the third quarter. For this quarter, next week, we will be handling trademark. We'll be hearing from Mrs. Uche on counterfeiting. We'll be hearing from Mr. Folarin on valuation, something else that has to do with trademark. Then we'll also be hearing from Mr. Ayokunle on trademark registrations, and it's going to be a packed Friday, next week Friday. So please, let's ensure that we come here early and that we come to learn. And we'll be having our closing ceremony upper week. We'll be having a SAN come to give the keynote presentation, and also a permanent observer of the World Intellectual Property Organization. So we would encourage that everyone joins us, and we'll also send an invite to all the mentors that have been mentoring throughout this quarter for them to come. We want to try to talk to the mentees on how they can get job placements, how they can start their own IP law firms and all that, so that they would be living with a clearer pathway on how to continue their lives and their careers and their businesses. So thank you so much. I'm happy that we're closing early today so that we can enjoy our Fridays. Thank you, everyone, and have an amazing weekend. Thank you.
Thank you very much. All right.
Thank you, ma'am.